These will be the People News, part 3. Alrighty. Without prejudice or recourse. Alright, I'm not waiving any of my rights. Never look straight forward. Always look around you to be able to benefit your whole family and be able to protect them by any means necessary. Alright, this is continuing part. This should be the last one of this deal. So, let's go ahead and proceed forward. It's getting early instead of late now. It's 3 o'clock in the morning. Coffee's getting made, and eventually I gotta hit the bed.
Time shall, together with the then current supplement, if any established prima facie evidence, or prima facie, the laws of the United States, general and permanent in their nature, in force on the day preceding the commencement of the session, following the last session of the legislature, which is included, provide, however, that whenever titles of such code shall have been enacted into positive law, the text therefore shall be legal evidence of the laws therein contained. In all the courts of the United States, the several states, and the territories and insular possessions of the United States, therefore, Title 42, USC 666, the child support provisions used to deprive me of my rights, my unalienable rights, are not legal evidence of law. It is done under color of law. So I just removed their veil. The emperor wears no clothes. Look at his little smeckle. You know, you can see it. Everybody point and laugh. They're all going to laugh at you, Judge. I just removed your clothes, your garb, your drape. You have no immunity, no protection.
His dress.
Period. All right? And you can't possibly be operating in good faith because your actions show otherwise. I, Dirk Gonzalez, am being deprived of rights, privileges, and immunities under color of law. I, Dirk Gonzalez, was born free. Free means not subject to legal constraint of another. Not hard, people. I am no longer free, having the power to dictate upon my own free will according to Title 4D order. If I do not comply as requested, I, Dirk Gonzalez, am subject to what? Jail, license suspension, commercial and recreational license suspension, wage withholding, tax withholding, rights to my offspring, the right to acquire property, the right to pursue happiness, the right to privacy, the right to protect my reputation, the right to independent and equal protection of the law, the right to not self-incriminate, federal grants and loans for businesses, etc., all while being denied my right to due process, which is yet again another rights violation executed by persons, USC 654-3, Title 4D, and his contracted agents, CFR 302.34, counties, agents, and agency and political subdivisions. It's important to note, I received not one letter from the FBI, Secret Service, DOD, DOJ Criminal Division. There were so many agents I wrote, and I got no response out of this, guys. Do you know how powerful this is? None. No response means the next time you come at me, Lucy, you got some damn splaining to do. Because there is an inquiry before this corporation, and by God, the heaven be willing, the great divine creator give me strength, you will answer this first. My controversy takes precedent over your innocuous bullshit to lie, loot, plunder, and steal from me. Number 10. Who are the persons in violation of Title 42 USC 654-3, Title 4D, and the Title 45 CFR 302.34? Counties, agents and agency, political subdivisions, okay? City, state, counties, they're all guilty. They are persons, all right? Not men and women, persons. Corporations that have trustees that are working for them. And our Ham jurisprudence 63 Charlie 2D states that all public officials, agents, and agency are in fact trustees of the American people. Period. End of frickin' story. Judge, Are you denying the trust? Are you disclaiming the trust? Are you saying that it's not there? Oh, I dare a public official to answer that one incorrectly. Boy, oh boy, would their nuts be on the chopping block immediately, warring against the Constitution, which is in fact a trust document. It's a trust document. I'm not a signer to it, absolutely not. But it's the intent of the testator, the grantor settler at that moment in time, that I not be frivolously accosted against my will, that I not be forced to warehouse any agent and agency, that I not be forced to testify against myself and incriminate myself, that I have the right to be secure in my persons, paper, houses, property, and effects, which is really what, ladies and gentlemen, the pursuit of happiness. All right? Provided I do what? Do no harm to another man or woman. Period. They are persons and do not have immunity. The USC 654.3, which is Title 42, 654.3, is a single and separate unit. If it is a single and separate unit from the government with customers, how do they have 11th Amendment immunity? Well, I went ahead and answered that for them. They do not. Nobody wrote me back and said, Derek, you're absolutely wrong. You're on crack. Lay off the drugs, buddy. Quit hitting the bottle. Go to sleep. Quit studying this stuff. Not one letter. Yeah, you're correct. We're so sorry. We're going to correct this right now. The least they could have done was tell me, fuck you. I mean, I could have at least respected that. Hey, Derek, hey, by the way, psst, fuck you. Oh, okay, well, all right, cool. No response sometimes is the biggest insult a man can receive. It's frustrating. But at the same time, it's very gratifying to know, checkmate, I got you. P, presentment of bills, okay? Now, in the child support hearing, they allege that I owe a debt. Well, in order to be a debt, understanding commercial law, there has to be a true bill due and owing. Before it could be a debt, there would have to be a true bill. And the true bill, I learned about this unwittingly and unknowingly, running my own businesses, doing my own private thing as private trade in order to survive, create a living, right? And it's funny because you create an estimate and everybody goes over the estimate and we agree and we understand that there's maybe a 5% margin on the estimate to go up and down either way, all right? It could be for the homeowner's benefit, it could be for my benefit, but I got to leave some leeway in there because, again, it's just an estimate, and they may, the materials may fluctuate or whatever over time as we're getting the project done, so we need that 3 to 5% leeway there, and that's the estimate. A bid is something solid and firm, right? So we got the estimate, we get the estimate signed, I have the estimate in my hands, I'm now the holder in due course, and this is what I found interesting about banking. Having that instrument in my hand, I could literally go to the bank and give them that estimate, that signed contract to perform the work, and they would lend me the funds based off that agreement. You can call it a promissory note, you can call it a contract, I don't give a shit what you call it. They can monetize it, and that by itself was proof of how the banking system works. That we as private men and women can create our own instruments, okay? We can create our own contracts, and the bank will be more than happy to take that slip of paper from you and monetize it because they know you don't have enough common sense to ask for it back when that contract is completed. You do all those rights, titles, interest. If they monetized it for whatever it was, you do all that back in owing once you satisfy the contract. So once the work is done, the next step as a man engaged in business or fair trade is to correct the record, because it was an estimate. Maybe we were under by $1,000, so we take $1,000 off the $8,000 bill. It's now a $7,000 true bill due and owing. I give notice to the homeowner that there's a true bill due and owing for $8,000, and I have the original in my hand, which is evidence of the debt, and it's evidence of the payment due, right? And I have evidence of the signed contract estimate to perform the task at hand. Everything's satisfactory, everything's done, and I send them notice. And they decide not to pay their bill, okay, the true bill due and owing. Then I move in a private administrative process to default them. Is it your intent not to pay this bill? It's due and owing. I'll give you 10 days to respond. If you don't respond, I'm going to presume and assume that it's your intent by your tacit agreement and acquiescence to shirk your responsibilities and obligations and not pay this bill. And in doing so, you're going to cause me harm. Trespass by way of debt at this point, because if you're shirking your obligation, now it becomes a debt, and that's trespass by way of debt. It's not trespass by way of bill, it's trespass by way of debt. The bill was the positive credit that was owed to me. By denying it to me, now it's a trespass, right? And it's a trespass by way of debt, failure to pay your obligation as an obligor. The child support agency can never produce a true bill due and owing with a wet ink signature stating who, what, when, where, how, and why, itemized list of how I owe this alleged debt. And if you're alleging that it's a debt, then there must first have been a bill. And if there was no bill, then it's a denial of due process, and they're bringing forward a false claim for which relief cannot be granted. I can't satisfy something that wasn't brought true, correct, and proper, okay? Derek, do you have a demand response within so many days? And if they do not respond in a time, they are in default. Yes, I'm explaining that process. It's really simple. I actually learned it from the credit card companies. I started watching what the credit card companies were doing. They would send a letter. There's this alleged debt due and owing, and they would send a statement, never a bill. And I'd ignore it, and then all of a sudden I'd get this default notice from the court after 6 months of ignoring them. They defaulted me. And basically they're doing the same thing that I'm explaining to you now. How to administer a private administrative process. Our process is a little different, because commercially they get away with murder, essentially. They don't notarize anything. They don't sign anything. The CEO doesn't sign anything. These people aren't actually doing their jobs and holding any liability. They're doing it under the guise that you don't know what's going on. And under the Consumer Protection Act, you have a right to be made whole. You have a right to be protected. It's your credits they're holding on to. So anyway, we'll get back into the child support. I just wanted you to comprehend, and I hope I did a good job of explaining it. If there's no true bill due and owing, then there isn't a debt. And you're about to find out how deep I'm willing to go on this, because I articulate it very beautifully in the next few pages here. Presentment of the bill standing, substantiating the alleged allegation of an existing debt owed. All right? Derek Gonzalez have demanded the presentment of the original bill. Come forward if you're the true holder in due course of the original instrument. I just need to see it. Bring it forward. Multiple times from the alleged prosecuting attorney, Brandon Brownell Hansen of Valley County, Nebraska. Brandon Brownell Hansen, who I always called him Karen Lynn Noakes Barnyard Pimp, because that's what they are. Those little prosecutors are just barnyard pimps. Brandon Brownell Hansen has failed to produce the original bill. Well, if there's no original document, no original bill with wet ink signature, who the hell's got the balls to make a claim like this and not be independently bonded? Well, I'll tell you who had the balls to do it. Brandon Brownell Hansen, like a jackwagon. To substantiate the alleged allegation of a debt, Brandon Brownell Hansen has failed to provide power of attorney for the state of Nebraska, which is his alleged client. No more real than Kris Kringle, Easter Bunny, Tooth Fairy, you name it, whatever you want to call it. Or Piper Madison Gonzalez, alleged plaintiff, or Janae Cherry Baker, alleged payee, which he proclaims to be conducting doing business on behalf of. But, as I articulated to you earlier, he's not doing business on behalf of any of that. He's doing business on behalf of the state treasury. Brandon Brownell Hansen, there's forged documents all over, false and fictitious claims, using false and fictitious names, trying to extort from I as a man my way of making a living. Brandon Brownell Hansen has failed to provide an affidavit of truth from his alleged plaintiff, affiant, stating harm, injury, and/or loss or rights that have been violated. Brandon Brownell Hansen has failed to produce his alleged license issued by the state of Nebraska to practice law, because that was a fun one. And a little story, a little ditty about that. I've got some very, very, very learned friends. I would put them against anybody in a court of law, and or at law, in law, whatever you want to call it. And they're so sharp, if they're in the wrong, they'll tell you right away, hey, I'm in the wrong, I'm not going to win this, I'm in the wrong. They're correct in their assessment of what they're doing. We're wrong. Needless to say, I brought him in as counsel. And in the Constitution, it doesn't say I have a right to an attorney, a lying, looting, pandering piece of shit. It says I have a right to counsel. And then there's a maximum of law. It says he who makes a hasty decision without consulting counsel first, when consulting counsel, is in vain. And I paraphrase that, so it's horribly wrong, but you get the gist of it. He who does something ill-advised and then comes back for advisement after the fact, it's always in vain, all right? Karen Lynn Noakes' alleged non-biased third-party judge stands firm that one must possess such a license in order to represent an affiant or plaintiff. Well, an affiant or plaintiff are in the fictional realm, so I agree with that. But on the other hand, you've got me in there as a man under threat, duress, and coercion saying that if I don't show up, you're going to arrest me. So I'm naturally here, and I'm not here to defend or represent myself. I am myself. So who's got the true bill due and owing that it caused harm, injury, damage, and loss to? What financial interest do they have? What species do they require? And I'll go out there and provide remedy right now. All I need is a man or woman to come forward. Oh, you see, Derek, the state is alleging. Fuck the state, you lying, looting, pandering piece of shit. You're full of crap. And how do I know he's full of crap? Because he clearly understands the Sixth Amendment is not only there to protect my unalienable right to face my accuser, but also there to protect me from being fleeced so they can unjustly enrich themselves. So we know that he's in collusion and conspiracy against you as a man to fleece you of your labor, all right, and get documents from you because they can monetize them. This is my issue. When I started seeing this stuff for the first time, guys, this is what got me into the books, looking at it, talking to very articulate, intelligent people, day in and day out. And I'm talking about lawyers that have been in the business for 35 to 40 years. And I was talking with them, and they're going, look, what you're discovering, we figured out when we were in our mid-20s. What did you want us to do? Stand up. Sound off like you got a pair. This country's in trouble. So, Derek, everything you're learning is true. It's all smoke and mirrors, buddy. Keep going. Keep up the good fight. But unfortunately, at this point, I can't help you anymore. And please don't contact me from this point on. Okay? Because it's dangerous, ladies and gentlemen. But the encouragement from this man, redeeming his soul by telling a young man who was hard-pressed for the truth, the whole truth, and nothing but the truth. I have some admiration for that man. I have some admiration for that man. Because everybody else in my family thought I was crazy. Everybody else was telling me I was wrong. I was suffering from PTSD, if you will. And rightfully, all of you suffer from PTSD because you've been lied to your entire life. And coming out of this is going to be a shell shocker. It's a big deal. Some of you aren't cut out for what this entails. Some of you will fall back in line, and it's okay. It's not for everybody. There are some of us that are just naturally born fighters and warriors. And we're supposed to protect the weak, defend the poor, and bring stability throughout the community. The warriors, men and women alike, even offspring, believe it or not. I've seen some young 13, 14-year-old kids that can articulate equity like you wouldn't believe. And I know it's because their parents, their mother and father, instilled good traits and qualities in them. And it's just amazing. So you can learn from everybody. I learn even from the most ignorant men and women and offspring. I do. And you'd be foolish not to. You know what's impressive is something I came to acknowledge as a young man. I've never learned from a physical fight that I've won. I've never learned anything from it. But I've always learned from a physical fight that I've lost. I learned how to duck, how to move faster, how not to stand in one place. So sometimes getting knocked down, ladies and gentlemen, is just part of the process of growth, and it's painful. And when it's painful so often, we learn those lessons, and we make sure not to make those same mistakes, right? So Brandon Brownell Hansen has failed to present documentation establishing he is bonded on CI 1658, Valley County, Nebraska District Court, in the event he causes harm to I, Derek Gonzalez, as a man. The original bill is required and a crucial element for standing before the court. Without a bill in question, the element of jurisdiction cannot be established, nor can relief be granted. Do you guys understand how powerful that statement is? I'm here to provide remedy. I just need the bill. Give me the bill so I can assess it. I'll sign off on it, and we can take care of this matter. They never could produce the bill. They created an impossibility. Brandon Brownell Hansen, contracted under CFR 302.34, is not only an agent and agency for the Title 4D agency through USC 654.3, but also is contracted through the Nebraska Bar Association. Ladies and gentlemen, clear-cut conflict of interest. Period. Brandon Brownell Hansen has failed to establish jurisdiction for and on the official record when challenged. Brandon Brownell Hansen has failed to produce and present his oath of office and bond upon request. I, Derek Gonzalez, cannot accept the original bill if Brandon Brownell Hansen refuses to present it, ladies and gentlemen. How can I accept and acknowledge something? How can I remain in honor if you won't give me what you allege you have? So I can honor it. If Brandon Brownell Hansen has the original bill and will not present it to I, Derek Gonzalez, then it is clear Brandon Brownell Hansen is in violation of my right to stand in honor and fulfill my obligation as a man. That's all I want to do. I just want to be a man. Want to be treated like a man. Want to treat others like men and women that they are. Want to treat everybody with respect. But don't question my intelligence by pissing on my back and trying to convince me that it's raining. If Brandon Brownell Hansen does not have in his possession, or in due course, ladies and gentlemen, original bill, one can stand to reason that Brandon Brownell Hansen may be perpetrating fraud against I, Derek Gonzalez, also bringing fraud upon the court under the guise of the color of law as an agent and agency contracted through the Title 4G agency, USC 654.3, Title 4D, through his contract, CFR 302.34, for the benefit of the State Treasury of Nebraska, as well as Brandon Brownell Hansen's personal gain. Unjust enrichment, ladies and gentlemen. All right. Karen Lynn Noakes, alleged third-party, non-biased judge, Karen Lynn Noakes, failed to produce her oath of office and bond upon demand of I, Derek Gonzalez. Karen Lynn Noakes entered a plea allegedly on behalf of the alleged defendant, Derek Gonzalez. It is very clear a plea was entered on behalf and collected in interest of the prosecuting attorney, Brandon Brownell Hansen, Valley County prosecuting attorney, so they could proceed with the fleecing. That's conspiracy, ladies and gentlemen. Bam. Nobody rebutted it. Karen Lynn Noakes denied I, Derek Gonzalez, the right to enter into an informed plea by failing to answer questions pertaining to jurisdiction. Denial of my substantial rights and due process of the law. Guilty. Nobody rebutted it. Karen Lynn Noakes' failure to acknowledge questions being asked by I, Derek Gonzalez, showed a clear bias in favor of the prosecution, as well as exhibited ex parte behavior. Now, this statement right here, exhibited ex parte behavior, I can prove it, but the officers and agents that were in the room at the time more than likely would never testify, even though some of them were retired and were astonished that the prosecutor and the judge, in the midst of a hearing, walked into chambers and came back out to continue on and approached the bench multiple times to have a conversation and then resume the proceedings. Ex parte communication, all right? Now, ex parte isn't a bad thing as long as you're in the right jurisdiction. You're in equity, the exclusive jurisdiction of equity, using Gibson's chapter 1 through 60 as reference points, waypoints, guide points, and navigating those treacherous waters of commercial law. Karen Lynn Noakes did in fact partake in ex parte communication with the prosecutor Brandon Brownell Hansen on multiple occasions throughout the legal proceeding. Karen Lynn Noakes' seditious behavior, and I chose to use the word seditious because it was seditious in nature, and it was something else. Behavior is notably incomprehensible, extremely unprofessional, and was witnessed by many throughout the proceedings. It's important to understand that when I was going through this, I was drawing 30, 40, 50, 60 people into a court. That's how many people were leaving their jobs at 1 o'clock in the afternoon to come watch the shit show, all right? And it was powerful because the people that cared enough to be there, whether they were there for the shenanigans or whatever, the George Carlin moments, were really there to find out what I was pissed about, and it helped in prevailing. Any reasonable man can understand what I'm talking about right here. So, from yelling from the bench, failure to answer questions, practicing law from the bench, promoting the prosecution, Brandon Brownell Hansen prompting Brandon Brownell Hansen to enter motions when he had said not one word in 6 months. You know, the telepathic ability of Karen Lynn Noakes is amazing. it was bewildering to me. The alleged judge would sit on the bench and prompt the prosecutor, didn't you want to file a motion today? Yes, as a matter of fact, I don't have it quite written up yet, but I do want to enter a verbal motion. Are you shitting me? I mean, how much assistance are you going to give this guy? In order to avoid my questions, Karen Lynn Noakes failed to provide I, Dirks Gonzalez, with a trial by jury. As demanded, Karen Lynn Noakes denied I, Dirks Gonzalez, my Sixth Amendment, and it's not a right. Again, another misnomer, but we lean into equity to comprehend the intent, which is to enforce the Sixth Amendment, to not allow egregious encroachment by agents and agency upon my unalienable rights. As per my demand before the courts for a trial by jury verbally, all right? Karen Lynn Noakes denied I, Dirks Gonzalez, the right to counsel. Now, that's a substantial right violation, and you need no conclusion, or the case doesn't have to be closed in order to come in with an interlocutory appeal to the appellate level about your substantial rights violation. They got a cute little way about skirting around your right to counsel. It's just real cute. You'll figure it out. Karen Lynn Noakes falsely arrested I, Dirks Gonzalez. Why did I say that? Contempt of court in a child support hearing cannot be had because now they're acting judicially instead of ministerially, and it's the perversion of the separation of powers. After I had challenged jurisdiction without addressing the issue of jurisdiction that lay before the court, Karen Lynn Noakes denied I, Dirks Gonzalez, the right to a speedy trial. Karen Lynn Noakes had engaged in conversation via the telephone with Tim Totson, a Valley County resident, about I, Dirks Gonzalez. It just so happens Tim Totson frequents my parents' home for conversations and cocktails. This conversation took place during the months of proceedings, whereas Karen Lynn Noakes was to remain non-biased. This information will undoubtedly be substantiated through phone records and first-hand knowledge by Tim Totson. Now, whether or not I can get this joker, to testify against his own family, probably not. But here's the facts. The phone records are undeniable, all right? So, Karen Lynn Noakes was demanded by I, Dirks Gonzalez, repetitively to recuse herself as to her unprofessional conduct, seditious behavior, ex parte communication. Karen Lynn Noakes clearly violated canons set forth to ensure a proper and fair, meaningful hearing. Karen Lynn Noakes has a huge conflict of interest in the matter that cannot be overlooked, whereas Karen Lynn Noakes is a bar member, is contracted under CFR 302.34, receives compensation from the state treasury, as does Brandon Brownell Hansen, who also is bar member paid by the state treasury. Both are gainfully employed, not only by the state of Nebraska, whereas they receive their salaries and pensions. Both Karen Lynn Noakes and Brandon Brownell Hansen are in fact contracted with Title 42 USC 654.3 under CFR 302.34. The Bar Association is also contracted to the Title 4D support USC Title 42 654.3. Let me remind you, Karen Lynn Noakes, as well as Brandon Brownell Hansen, are Bar Association members contracted with all three entities simultaneously. Where is Dirks Gonzalez' right to a fair and meaningful hearing again? Karen Lynn Noakes is in violation of the Separation of Powers Act, whereas Karen Lynn Noakes is operating in the executive branch as an ministerial administrator for the benefit of Title 4D Title 42 USC 654.3 as a single and separate entity person, whereas Karen Lynn Noakes must adhere to her contract CFR 302.34 to enforce provisions and enrich the Nebraska State Treasury. Title 42 USC 666 falls under the Social Security Act in the executive branch. Thus, Karen Lynn Noakes is in clear violation of Separation of Powers Act. Karen Lynn Noakes no longer qualifies for judicial 11th Amendment immunity, as in her violation of the Separation of Powers Act. She is now operating in her personal capacity, subject to liability and damages she may cause in her actions. Adjudication without presentment of a bill. Karen Lynn Noakes, how do you assess this sentence without a bill? All right, without a true bill due and owing, how do you substantiate jurisdiction? How are you able to render a sentence without the thing of value being before you in order to assess the situation? Karen Lynn Noakes, how do you decide a value assessment without having the thing that is valuable? Karen Lynn Noakes, how do you create a bill contempt charge for this sentence? Karen Carolyn Noakes, are you waiting for me to accept your bill that you probably have not written before you negotiated? Because remember, she's a banker sitting on a bench. All right, it's all in Black's Law Dictionary. It explains to you exactly what they are after 1933. They're bankers, period. Handling financial instruments and negotiating them. Carolyn Noakes, is the value of the payment of this alleged debt to be made with money? Carolyn Noakes, what species are we talking about? Currency. Carolyn Noakes, by currency, do you mean I am to use the bankster's private property, printed paper pledges of credit instead of my own already on deposit to set off this debt claim? Carolyn Noakes, what is the value in the bankster's paper currency, Federal Reserve notes, fiat of this sentence? And furthermore, if you're going to tell me that I need to use Federal Reserve notes, one, I need to know what your private interest in a private for-profit corporation identified as the Federal Reserve that's privately owned is, and why I have to use their intellectual, private, copywritten, trademark property to satisfy and indulge you or your principal, right? What's your interest in me using their shit? Carolyn Noakes, what is the value of warehousing sentencing of 1 year of Derek's body, a month, a day, okay? Carolyn Noakes, are there different sentence values coming from different judges within this venue pertaining to the same subject matter, right? We want to know if all their judgments are the same and unanimous across the board, because they're not, ladies and gentlemen. If you piss them off by asking too many questions, your sentence is more severe. If you go along to get along, you might just do a few weeks in the pokey, you know, while you abandon all your rights, titles, and interests. Carolyn Noakes, are your sentencing values the same for everyone you are assessing? So basically, on all the child support issues that you handle, are your assessments the same on every last one of them? As far as how long you'll warehouse my body while bonds mature and securitize? Carolyn Noakes, are you sentencing values the same or similar to other judges' assessments? Carolyn Noakes, does the warehouse sheriff's facility, which is the warehouse for the body, get paid for keeping my person while enforcing your sentence? Very important questions. Nobody answered them, ladies and gentlemen. Does that make me crazy? Well, I don't know. That's for you to decide. Carolyn Noakes, does any part of this debt claimed get paid from whatever source is paying to warehouse my person in the sheriff's facility? I, Derek Gonzalez, have not been presented or shown a claim or bill showing I, Derek Gonzalez, owe a debt to anyone in Valley County District Court, CI 1658. I, Derek Gonzalez, have never seen nor laid eyes on a bill, a true bill to an owing. Therefore, I have no idea what value is being claimed or billed to my property, my estate, right? And I'm going to leave you with this because my throat's getting sore. We're on page 11. I'll come back. We'll do round 2 on this. Or maybe we'll just put it in selfgovernanceU.com and participating members can enjoy the rest of the story like Paul Harvey. I don't know. This is so important, guys, what I'm sharing with you. None of this is rebutted. Nobody's got an answer. All right? So classes are coming up. This is the kind of intense detail we get into. I mean, next is the conflict of interest. I can't stop at this point. Conflict of interest, Corpus Juris Secundum, CJS, Volume 7, Subsection 4, Attorneys and Clients. Man, these lying, looting, pandering pieces of fecal matter.